face it, the biggest reason for families to get fractured and siblings to go to war with each other is property. If you don't make a watertight property will or do adequate estate planning, it may end up becoming the cause of a rift in a loving family. Joining me today to figure out how to do that are Surabhi Marwah, partner at EY India, and Divi Dutta, corporate and private client lawyer and partner at Shardul Amarchand Mangaldas CO. Straight into the topic, Surabhi, how complicated or easy is it to make a property will?
So, making a will actually is not complicated at all. You can do it on a piece of paper. What you need to be really careful about is what are the important things that you need to tick off. Now, whatever are the assets that you want to put in the will, for example, if it's property, make sure that the location, the area, the size of the property, all of those things are very well captured. The people that you want to leave it to, which is the beneficiaries, write their names clearly, their PAN or Aadhaar numbers clearly, very simple. You need to make sure that you have two adult witnesses who are signing the will. Don't forget to do that. Make sure that things like, a medical certificate, because a will is normally challenged by saying that the person who made it was not of sound mind. That is also available. You should have an executor, a person that you trust. If you do all this and you have a proper annexure, proper details, even if you don't register this will, and this is a common question we are asked, that will is still valid and is still legal. So I've had a situation where one of my colleague partners, he was 57, suffering from COVID, and I'd been talking to him about making a will. He hadn't done it. When he got COVID, he called me and he said, I'm going to take a piece of paper and write it all down. Will it have any validity? I said, it should if you follow these points. So it's as simple as that, if you don't want any complication in your life or the lives of the people you leave behind me.
Absolutely. In fact, I must also confess that the first time I got down to putting anything on paper was when the second wave of COVID happened, because, all of us were just shaken out of our slumbers and said, look, our mortality is just staring at us, right? Divi, where are the biggest fights which happen? Is it because the will has not been made or the wills are not clear enough? Because, if you look around, it's the maximum strife I see between siblings is over real estate and property matters.
No, Manisha, absolutely. And in fact, I just want to add that even if a will is made, you still can't avoid the fights. But as you rightly said, and I see Surabhi also nodding, it's always best and advisable to have a will in place. But having said that, given that, we're talking about property, the biggest challenge here is because there are different classes of property. It's not always property which is self-acquired. When I say self-acquired, is property that you bought with your own money. That's the easy part. But given, the patriarchal system we have in India, we have property, which flows down through generations. Our fathers, our forefathers, and our, great-grandfathers have not made wills. So then these get classified as ancestral property, where people have a right through birth and not through will. So that is, of course, one big challenge, we see trying to, trace the lineage and, what is the classification of that. Second is, of course, your Hindu undivided family. If there is a property which is contained in a Hindu undivided family, again, that is not something that can be willed, because, it is normally shared between the co-partners of that Hindu undivided family. And the third and the most common piece is, properties which are in joint ownership. So effectively you cannot will the entire property because you don't have 100% share. So if all of these are overcome, and I absolutely agree with Surabhi, it is fairly easy to make a will, but the challenging part is, writing down these details or, capturing these, correctly to avoid any disputes. And I also want to add that the description of the property, although simple, should be as clear as possible, just to avoid any kind of disputes. We don't expect you to attach, your sale deeds and things like that. But at least if you can, clearly, write what the property description is, where it's situated, and preferably make it as clear as possible. That is also one way that, you can avoid disputes.
Interesting. Surabhi, how is estate planning different from making a property will? I know that estate planning is only when you have large estates, but even then, is there any difference, and what is it?
So estate planning, the connotation of large has changed, and we will understand as when we get clients some say this is large, some say this is large. So estate planning, making a will is a part of estate planning. A lot of people think estate planning means only trust. Estate planning means that whatever you hold in your lifetime, whether it's business assets or personal assets, financial assets, are passing down as per your wishes, which is the wishes of the person owning them. But you can do it in two ways. One is that you can do it through a will. One is you can do it through mechanisms such as trust, etc., which is, so you design irrevocable or other trust, which is a very, very common phenomenon. Or you do it as a combination of both, a will and a trust. And sometimes we do it in a manner where some part of the property goes into the will, some part of the assets go into the trust. But it really depends upon the type of assets that a person owns and the wishes. Very often large business assets, etc., are done through the trust because you have several generations and you want to have, charters and trust deeds, etc. So it's a combination of both, and we always suggest a combination and not everything bequeathed through a will or through trust. Now, mind you, in some cases, even a trust may not work. I mean, in India right now, there is no estate duty. But, in some countries, they say that, the trust mechanism is even challenged. So even though you have US and UK, you have foreign grantor trust or Delaware trust, a lot of governments are challenging that. So when estate duty comes into India, we don't know whether they're going to open the corporate veil and challenge the trust. But as of today, the only big difference is the trust may help you escape or manage estate duty if and when it comes in whatever form, unless of course they put trust in, while a will not really help you prevent estate tax or inheritance tax. But a combination of both is what is the right thing to do.
Okay, I'm sure people come to EY for that, and also to Shardul Amarchand Mangaldas when they want that kind of detailed planning. Very quickly, Divi, I believe in a will, or you can also actually mention something about future properties that you might acquire. Is that even possible? And any taxation or inheritance tax that one should be careful about?
So absolutely, Manisha, not only what you can acquire in a will, you can actually, have three different concepts built in. What we actually typically do, one is property which is not mentioned. If there is some property which you own, which you have accidentally left out, you can actually cover that to say that any property that I have not specifically mentioned, should be dealt with, ABC, manner. Secondly, of course, any property that, you may acquire in future, that is also something that you can mention just to avoid, having to make wills again. And if you're sure that, your legal heirs are the only ones you want to give it to, so you can also add that any property that I may acquire after the date of this will should also be dealt in a particular manner. And thirdly, as you said, any property that one may inherit, whether from your relatives or whether from your parents or whether from your spouse, even that can actually be put in as a bequest at the time of making a will. I also want to add one point that in estate planning, a will is something that can actually not be done away with. Even if you do a trust or whether you do not do a trust, you will still have to do a will, because once you set up the trust, and as I said, there is property which you may still own, which you have not put into the trust. And let's say, God forbid, something happens to you suddenly, then that property can actually be transferred into the trust through a will. Also, property which you may acquire later, property you may inherit from somebody even after your death, that does not take away your right to inherit a property. So a will can actually be used to capture and tie in all the loose ends, even if you have a succession planning vehicle in force. So I would say a will is actually non-negotiable, and everyone, who is, of a legally valid age and who has some property that they are the owners of, they should definitely do a will.
This is fantastic and very informative session that we've just concluded. Surabhi and Divi, thank you very much for joining me today. And I'm sure this is going to be so helpful to a lot of people out there watching this show. And we will also put it out on digital in case you want to refer to it on ndtv.com. That's it from me. Thanks so much for watching, and goodbye. I'll be back next week, same time.